Yes, get ready for the legal dictation containing 720 words at the speed of 90 words per minute. The dictation will fluctuate between the speed of 85 to 95 words per minute. 3, 2, 1, start. This petition under section 482 of CRPC has been filed by the petitioner against the impugned order dated 22/1/2009 of the Special Judge CBI Delhi, whereby he had taken fresh cognizance of the offence against him under section 7 13 bracket 2 read with 13 bracket 1 bracket d of the Prevention of Corruption Act 1988 for short the act. The prayer is made for quashing of the impugned order and also the proceedings arising therefrom. The petitioner was working as JE DDA New Delhi. A criminal case was registered against him on 24/6 1997 under Section 7 of the Act on the basis of a complaint dated 24/6 1997 of one Radhesham, wherein he had alleged that the petitioner demanded bribe of rupees 1000 from him for favoring him in not demolishing his PCO booth. The petitioner was charge sheeted on 13/4/1998 in the Court of Special Judge under Section 7 and 13 bracket 2 read with Section 13 bracket 1 bracket d of the Act. The special judge, vide his order dated 6/2/2003, acquitted the petitioner on account of invalid sanction of his prosecution. The CBI took up the matter for obtaining fresh sanction of his prosecution with the concerned DDA authority. Fresh sanction for prosecution was obtained on 27/11/2003. The petitioner was again charge sheeted under the same provisions on 18/12/2008 in the Court of Special Judge, who, vide his order dated 22/1/2009, took cognizance of the case and ordered for process of trial. The said trial is presently pending before the special judge and was stated to be at the stage of consideration of charge. The petitioner has sought quashing of the impugned order dated 22/1/2009 and all proceedings emanating therefrom on the sole ground of inordinate delay in his prosecution. So far as the facts as noted above are concerned, there is no dispute that the instant complaint was filed against the petitioner on 24/6/1997 and that the petitioner was already acquitted on account of want of valid sanction of his prosecution and that he was facing trial of the same offence after grant of fresh sanction of prosecution and the matter was still at the stage of consideration of charge. The learned counsel appearing for the petitioner has submitted that the petitioner already having undergone the agony of trial for 6 years was again made to face the same trial without any fault of his. He submitted that the delay has seriously prejudiced him in as much as he would be deprived of his defense. By this order, I shall dispose of the pending application being IA number 11454 of 2006 filed by the plaintiff under Order 6 Rule 17 CPC read with Section 151 CPC for amendment of the plaint. The amendments sought by the plaintiffs are mentioned in para 12 of the application. Originally, the plaintiffs filed the suit for declaration, permanent, and mandatory injunction against the two defendants, namely Lakshmi Vilas Bank Limited and Canara Bank. The following reliefs were sought by the plaintiffs as per the plaint filed in the year 2004. Pass a decree of declaration that pursuant to the deeds of sublease dated 2011-1996, under which the defendant number 1 has entered upon the suit property bearing number 74 Janpath, New Delhi, and is in occupation as plaintiff's tenant, the defendant number 1 is bound to retain the leased premises till the entire duration of the lease ending on 2011 and pay rent as agreed for the full duration of the lease to the defendant number 2 to be credited to the escrow account of the plaintiffs, with the defendant number 2 pass a decree of declaration declaring that the notice dated 27/4/2007 sent by defendant number 1 to the plaintiffs are illegal, invalid, and void ab initio, and that defendant number 1 cannot wriggle out of its liability to continue with the lease of the suit property bearing number 74 Janpath, New Delhi, in terms of the deeds of sublease dated 2011-1996, pass a decree of permanent and mandatory injunction restraining the defendant number 1 from determining the lease prior to 2011 and vacating the suit property or till such time on discharging the entire liability owed by the plaintiffs to defendant number 2 against the rents receivable from defendant number 1, whichever is earlier. Stop over.